Hello, everyone, and welcome to Saunders on Security, the podcast where we talk everything security for the busy CISO. Now, I've got a fantastic guest with me today from Canada, Sharon Bauer, and Sharon heads up Bamboo Data Consulting. Welcome, Sharon.
Hi, thanks so much for having me.
Great to have you on here. Right, so those who listen regularly will know I have a very major passion for data and data privacy, and that's very much what we're going to talk on today. So Sharon, I think, tell us a little bit about you. What's the privacy landscape that you work in? What do you do on a day-to-day basis? Give us some idea there.
Sure. So thanks again for having me. So I am the founder of Bamboo Data Consulting. We are a privacy consulting firm. We help organizations, mostly small to medium enterprises, identify their privacy risks, help them build out a privacy program, a defensible position in the event that ever there was a privacy complaint or a privacy breach. I'm also a lawyer, a privacy lawyer, so I do provide privacy legal advice. You know, I started off my career as a litigator in insurance, something completely different than privacy. And you know, I was watching, it's a funny story. I was watching the Snowden documentary, the Edward Snowden documentary, and all of a sudden I just realized, you know, all this information that I was putting out there in various apps. I started recognizing the fact that a lot more was happening than what I was actually able to observe. And that really fascinated me. And I went through a phase where I just wanted to learn more and understand what was actually happening with all my personal information. And that led me to a passion for privacy. So much so that I decided to basically drop the career that I built for myself for 10 years and start a brand new career, pivot, and only focus on privacy. And I haven't looked back since. I love it. It's one of those areas that is constantly evolving. And for someone who is a learner, someone that always wants to continue to learn and likes the how fluid things can be, privacy is one of those areas that really fits those needs. Privacy is constantly evolving as new technology emerges and new uses of data emerges. There's always going to be some privacy element to it. I also love the fact that privacy allows me to use my creativity. There isn't one solution for any problem. Every organization is different. Every problem is different. They may look the same, but the way that you approach it is differently. And even our legislation allows us to be creative and gives us some leeway to figure out how to implement what they're telling us that we need to do. So being able to be creative, working with the companies to solve problems, to look at their business strategy and how we're going to meet those strategies, yet still comply with our privacy obligations under regulations is so much fun. And then lastly, the thing that I love about privacy and everything that I do with my clients is I feel that there's a social justice element to it. And I feel that I'm, you know, helping society in one way, even though it's behind the curtains and probably no one will ever know, and that's perfectly fine. I feel that I am making the world a slightly better place by protecting individuals and you know, what they share unknowingly often. So I love it. It's great.
Oh, you echo exactly the things that I think about when I think about privacy as well. It's such a moving, fluid thing, like you say, that it is exciting. It is the interpretations and all of that, and it's different for every business. So yeah, and I mean, we are having similar kind of stuff here in South Africa because our new privacy legislation is coming in, and we're in the grace period now before it seriously kicks in and the regulators get teeth. So we're in a mad scramble here. But you mentioned the legislations and things there. So you guys have Pipita in Canada. Can you tell us a little bit about Pipita? How does that work?
Yeah, so you're right. So Pipita is our federal private sector privacy legislation. So it only applies to private sector organizations. And although it is national, so across Canada, there are several provinces, which is Alberta, BC, British Columbia, and Quebec, that have their own provincial private sector regulations that are substantially similar to Pipita.
Just to make it a little more confusing.
Just to make it a little more exciting. You don't want to be too bored, right? And then on top of that, for anything that is like federal government agency, you have your Privacy Act. So they have their own privacy regulation. And then one step above or below, however you want to see it, is every province has a like a specific sector-based privacy regulation. So for example, in Ontario, which is where I'm from, we have a health privacy regulation, which is PHIPAA. In BC, they might have a different one, and in Alberta, they might have a different one. So, you know, it depends on the topic, it depends on the province, but generally you have it right. Pipita is the federal private sector privacy regulation.
Oh, fantastic.
Yeah. I hope I didn't complicate that too much.
No.
You talked about regulators, and by the way, congratulations for getting your own privacy legislation. I can't imagine how exciting and busy it is in South Africa right now.
Yeah.
And you talked about your regulators. So we also have regulators. On the regulator that mandates Pipita or oversees Pipita is the Office of the Privacy Commissioner of Canada, also known as the OPC. I might be referring to the OPC a few times during our discussion.
Good to know. Good to know.
So the OPC, look, they don't have a significant amount of power. And that has been an issue, which is starting to be addressed as we see some reform in Pipita, which I'm sure we'll get to in our discussion. We'll have to get to that. But apart from the OPC, again, every province has its own provincial regulation for those other regulations that I was talking about, where every province has its own little ones. But the OPC can't really mandate anything. So when there's a privacy complaint, an individual can go to the OPC. They can, formulate their complaint. The OPC can audit the organization upon a complaint and make recommendations to, improve their practices. Okay. Now, if it's not binding, the question is, well, why would any organization listen to the OPC? They are incentivized to do so because the OPC can apply for the federal court. So they could file an application at the federal court, and the federal court will hear a case de novo, which means it's like from scratch. They can consider the OPC's recommendation, but they don't have to. So if an organization doesn't want to go through that whole process, they're likely going to listen to the OPC or at least try to comply with some of those regulations, which is what usually happens. Not all the time, but usually.
Okay.
And then sometimes the OPC can just start its own audit just because they want to. And if that's the case, they can make recommendations, but they can't apply for the federal court. Wow. So that's pretty much, the way it's kind of structured here in Canada.
It's so interesting to hear that, because I mean, we've got quite different structures, and our regulators can issue fines, and I mean, we've got criminal penalties for certain data types and things like that. So it's a bit of it's a different shift for me hearing that. So we operate a lot more like on the GDPR side in Europe and so on. So fascinating. Speaking of the way we operate as well, so we in Pipita have 8 conditions to lawful processing. So for those listening, I mean, we've got these conditions, we talk about conditions, and they come from the OECD guidelines, which came around in 1980, I believe, and then was most recently revised in 2013. and it's 8 principles or conditions on how to deal with data correctly. And it was the guidelines on privacy and trans-border information flows, which was quite a mouthful. And it deals with being accountable and having security safeguards and things like that. Now, Pipita in South Africa, our 8 conditions practically mirror the OECD guidelines. So that's where the space we are in. So openness, subject participation, accountability, purpose limitation, got all of these in. What are the kind of things that you see in Pipita on that side?
Yeah. So I would say then Pipita is similar, but we have 10 principles. And we have the accountability, limiting collection, consent, choice, security, so on, retention, so on and so forth, monitoring and enforcement. And that is Schedule 1 to our Pipita, to Pipita. It's called the CSA Model Code. And that really does drive the way that you read the legislation. And it's funny, like when you look at Canadian-made privacy policies, they're often structured around these 10 principles. So if you're looking at a privacy policy where it says number 1, accountability, number 2, limiting, collection, and so on, and there are 10 principles, it's likely Canadian. So yeah, and one of those really important principles is consent. And there's been a lot of guidelines and I should probably say guidance from the OPC around that particular principle, because Pipita is it is a consent-based legislation. You cannot collect, use, or disclose personal information unless you have consent.
Okay.
So I would say somewhat similar. Yeah.
Somewhat similar, but still a little different. So, here we have, so there's a big focus on consent, particularly from consumers and people in the public sector. Because I think people do also see that, and it's the immediate thought, like I have to consent to you having my data. And we've previously had opt-out consent, so you could be added to a mailing list providing there was a way that you could opt out of it easily and things like that. So I think that there is a large focus from the public on that Pipita is consent-based. But I think what we see a lot of the time, and not even businesses seem to be aware of it, is in Pipita, there's a lot more to it than consent. So we've actually got basically 6 different mechanisms that can be used in order to process data. So, and I'm curious on your thoughts if there's, you say it's consent-based, so I'm gonna let you tell me, because I'm not gonna pretend to be an expert on that. But we have very much like the GDPR, where there's legitimate interest. So if you can justify that, we should be doing this for our business needs, there are ways of doing that. It's probably flying a bit close to the sun, relying on legitimate interest. But then there's also contract. So if someone's entered into a contract, then consent is no longer needed. And then consent for marketing, direct marketing, that kind of thing. So we've got these different spaces that also it's kind of fluid, and you've got to argue which one you're going to use. So Pipita, I can never.
No Canadian says it one way. You can speak to one Canadian, you say Pipita, the other one is Pipita, so don't even worry about it.
Fantastic.
Like, I can't even agree on that.
One of the universities, I think, actually posted a paper on the way different people pronounce it when I was looking for it. So, okay, I don't feel so bad. So you're saying it's consent. Do you have any other mechanisms like legitimate interest, things like that?
Currently, we don't. So currently, it really is just consent. And it really is kind of like the central feature for the legal purpose for which you can collect, use, and disclose. There are a few exceptions, but very, very few and far between. Express consent is the default. That is the best kind of consent you can get. We also have implied consent, and you'd have to, there isn't like this equation that if you check off these boxes, then you're okay. You have implied consent. There's some guidance around that, right? So if you're collecting sensitive personal information, you can't use implied consent. You really need to use express consent. If a person can't reasonably expect that you're going to collect, use, or disclose their personal information, then again, don't use implied consent. It should be express consent. So there's some guidance around that. You talked about marketing, and that made me think about Canada's anti-spam legislation, also known as CASL, C-A-S-L, not to be confused with C-A-S-T-L-E. And that is actually one of the most stringent anti-spam legislations in the world. And you really do need to get express consent. There are instances where implied consent is okay. The legislation is quite confusing, and there are lots of little pieces and parts that you need to put together. And you also need to be able to demonstrate that you've obtained the consent, whether implied or express. So like it's pretty complicated, and the fines are pretty significant, like $1 million for any contravention to CASL. But you know, the big thing with consent in under Pipita is that it really needs to be informed consent and meaningful consent. So, you know, saying that you put some information up on your privacy policy and therefore the individual had notice, and, you know, if they continue to use it, well, that's on them. They've consented to use the application, for example, but you didn't give them enough information. There wasn't enough disclosure of how you're going to use it, who you may disclose it to, what information you're collecting it for, and what is the purpose for that collection, then you don't actually have meaningful and informed consent, and therefore it's not valid consent. So the OPC has given some guidance around, okay, well, how can you obtain meaningful and informed consent? You know, the big takeaway from that, and what I love about their guidance, was be creative, people. Like, you are making technology, you are innovative people. Be innovative with how you're going to get consent from individuals. Make it just in time, make it dynamic. Like, come up with ways, like use the user, you know, interface. Like, how is a user going to look at this and understand that they are, you know, giving up certain information, what they're giving it up for? Be creative. And I love that. And that's why, like, going back to what we originally talked about, there's not one way of doing things. A privacy policy is not one way of informing people. There's so many other ways. And the more you do it, and the more information you put out there, again, if ever there was a complaint or a breach, that is your defensible position. We've informed this individual. We told this person or these people exactly how we're going to be using it. And we didn't just put it in our privacy policy. We had this pop-up that came up, or we gave a description just before they gave us their very sensitive information, or maybe we gave them an option to do it. So be creative, you know? I love that.
Totally. I'm a huge fan of just-in-time privacy notices. So I actually saw a fantastic thing on LinkedIn the other day, and I wish I could remember who shared it, but it was basically like a little cartoon strip explaining just-in-time privacy notices. And it's basically, if you arrive at a new city and you need to find directions somewhere, they don't give you the full map to the city as you get to the entry into town. You have street signs all the way along, which kind of guides you, like, okay, if you turn left here, you're going to get to X. If you turn right here, you'll get to Y. And I thought that was quite a nice little description of those just-in-times. And like you say, be creative as well.
Cool. Send me the link.
I'll have to try and find it. I'll go trawling through my history. But I mean, also talking about be creative, I think that's a really, really important piece of advice for people to be aware of. So we also have informed consent here. You have to have informed, positive consent that you can prove after the fact. And, you know, don't just say, well, we need your consent for a newsletter. You can actually say what value you're giving people, what benefit they're going to get, as well as inform them what this is. if you explain why and you do it in a fun, creative way, you can often get that consent that you're looking for much easier than just sending a dry, bland, horrible thing.
Right, absolutely. And also letting your consumers know that they have a choice. If they decide they don't want it anymore, they can always opt out.
Yeah.
And I think that that's really important in being able, like in your frequently asked questions section on your website, how do you opt out, giving them that information. I mean, I often find myself when I want to opt out of something, it's so hard for me to figure out how to do it. And I think that those organizations that put those details in on their websites or on their apps and show their consumers that, you know, we care about you, we care about your privacy, we want to enable you to have control. I think consumers trust those customers a lot more and are more willing to give up information. I know that's the way I think, and I think studies have shown that when a user feels that an organization does give the user a lot more control, that user is willing to give up a lot more information, which is better for business.
Yeah, no, definitely.
The competitive advantage, right?
Absolutely.
To do that.
We've got companies here, and some of the companies that I've worked with on their privacy programs, they're using that as marketing now. They're like, well, we have a privacy program in place. And we see it in, so one of the things in Pipita as well, if you're doing direct marketing, on your communication that goes out, there needs to be a visible, easy, free opt-out mechanism on every communication that goes out, basically. So it's here, we have to do that now. It's got to be easy.
Does that include communication for like commercial activity? So not so much like marketing or advertising, but if I were a company and I needed to talk to you about your warranty, or if you had an inquiry and I was addressing that, I'm assuming you wouldn't have to put the opt out on those kind of communication, just for marketing, right?
Yeah, so direct marketing is specifically mentioned with its own section and everything. And then we have other sort of forms of communications could be under either performance of a contract or legitimate interest. So like status notices and service notices and things like that. It looks like a lot of folks are starting to rely on legitimate interest there, or that it's part of a contract and SLA that they enter into. So
right.
Yeah, that's what we're seeing a lot there.
Yeah, and I mean, we can talk about some of the reforms to Pipita, but one of, you know, a significant reform is to the implied consent. And now what we're seeing in the new legislation is that legitimate interests or legitimate purpose is one of those exceptions. And so, and that would fall under the implied consent. So it's still very much consent based, and they've kind of put the legitimate interest, so long as it doesn't influence an individual to make a certain decision or influence their behavior in any way, then you can use legitimate interest as an implied consent. But that is forward when you know that legislation comes into force.
Yeah, and I'm very keen to find out more about that. Like legitimate interest as well, even under GDPR, has I think been fleshed out quite a bit more than what we're seeing. And I mean, we don't have case law yet, so I guess we'll see soon enough what happens there. But you mentioned reforms. What reforms are on the way for Pipita?
Yeah, so Pipita has been around since the early 2000s. With little to no changes, despite technology all around us changing in a significant way, despite the fact that our data is being used in a completely different way than it was in the early 2000s. So lots has changed other than our own law. And this is really obvious now that GDPR is around, and even CCPA in California is around, and it's like, oh my gosh, we're really different. And I think that there has been some feelings of being nervous about our legislation because we're fortunate enough to be viewed as an adequate jurisdiction. So we have adequacy standing in the eyes of the EU, which is huge for us. It's amazing. Like EU data easily and freely flow into Canada. And, you know, there, you don't need to have any special contracts in place or certificates in place. And it's just, it makes it really easy to do business between EU and Canada. So that's big. But the concern is that, well, if the EU reevaluates Canada, and we got that standing in 2006, which is, I think, about 17 years ago. That's a long time ago. You know, we're concerned that we're no longer going to have adequacy standing. So that might be the driving force to why we decided, okay, time for a reform, time to change things up and make our legislation a little bit more modern. And of course, you heard about Schrems 2 and the privacy shield being invalidated. And so I think that was like eye-opener, like, okay, well, that can really happen to anybody at any time, like boom, it's invalidated, or adequacy standing can be invalidated. Okay, so we completely reformed Pipita. It's not going to be called Pipita, which is great, because now no one's going to have the argument of how it's going to be, or how it's going to be said. Is it Pipita or Pipita? But it's going to be a little bit complicated. It's called the Consumer Privacy Protection. Consumer Privacy Protection Act, the CPPA, which is different than the CCPA.
Oh,
now
boy.
we just have a bunch of acronyms, which is wonderful.
Well, it's now, I can now refer to it as part of my 4-letter words. I often refer to privacy legislation as that.
Yeah, exactly. It's so funny. So some of the big changes. I mean, they say that they've modernized the consent rules. Quite honestly, I don't see it. I don't see it as huge modernization. I think, like we all know, you have to use plain language, which is now in our legislation, plain language, going back to the informed consent, right? You can't give informed consent if you don't actually understand what the hell is written in a privacy policy. So plain language. Express consent is the default, which I think, you know, pretty much is now anyways. And then I talked to you about that legitimate purpose under the implied consent. So to me, the legitimate purpose is probably the biggest change under consent. So that's consent. There's a whole big section about accountability, which I think is really interesting and important to put in there. I think it opens the eyes of a lot of organizations, private sector, to say, okay, so yes, we understand we're accountable, but we actually have to have a privacy program up and running, and we must demonstrate. Demonstrate is like the big word here. So if a regulator comes knocking on our door, we have to demonstrate for them, not only do we have these policies and procedures in place, but we've actually implemented them, right? We are complying with our own policies and procedures, which many organizations either don't have them in the first place or don't comply with their own privacy policies and procedures. Oh, yes. So accountability is huge. I'm also seeing some accountability for vendors or service providers, or you know, what you call processors under the GDPR. So currently in Pipita, there is none of that. A lot of it is contractual. So a controller or a business is going to enter into an agreement with a service provider or processor and have privacy provisions in place to make sure that, you know, they're protecting the information, they're informing them of a breach, so on and so forth. But now in the CPPA, service providers must notify the business or the controllers as soon as feasibly possible when there's a breach. So that's something new and something that I like to see.
Yeah, for our South African listeners as well. So controller, processor, you can relate to responsible party and operator on our side, just to add some more confusion there. So.
Oh, God. You have to keep a lot of words straight. Like even under the CCPA, it's like everyone has a different name, and then the GDPR, it's complicated, but
why can't we just pick one?
I know, seriously. Someone needs to like create a privacy dictionary, and that is it. Like everyone uses the same universal term. Like what's so hard about that, people? Okay, so going back to the CPPA, there's some enforcement provisions. The big one are the fines. So you can be fined $10 million or 3% of your global revenue, whichever is higher. So similar to GDPR, where like
those before.
Big fines, and then for like egregious contraventions, you'll see up to 25 million or 5% of your global revenue, whichever is higher. So that's interesting. The OPC now has a few more enforcement powers and can make recommendations for fines, as well as, instead of the federal court, we now have a privacy tribunal, an administrative tribunal. And so any appeals from the OPC goes to the tribunal. So it's a little bit more structured and kind of nice. We have some more rights. So similar to GDPR, we now have a data portability right. We have the right of erasure, which we don't have under Pipita. And the right to have transparency around automated decision making. So, you know, need to have explainability, transparency around AI tools and machine learning, which is, again, something that we don't currently have. We have some guidance around it, but nothing in our legislation.
Okay, wow.
So
like
the big ones. Yeah.
Some significant stuff coming there.
Yeah. Now, again, this is all a bill. There still needs to be, like, they're holding a lot of like consultations around it, and nothing is set in stone yet. But we believe that in about 18 months, some legislation similar to the bill that's been posted will come into force. So it's going to be interesting times in Canada, similar to what I'm sure you went through in South Africa.
Yeah, holding thumbs.
Yeah.
So, you know, just bringing us to a bit of a close, I'm conscious of our time. There's a question that I ask every single guest that comes on the podcast, and I've had a different answer every time, and I'm very curious to hear yours. If you had to think of a quick win or a quick sort of victory piece of advice for security or privacy in an organization, what would you give as advice for that?
Okay, so that's a hard one because every company is so different. And we talked about there's no one solution for anything. But I don't think no company can really address any privacy issues until they conduct a privacy risk assessment. And for those companies, and I've seen them that say, well, we'll just put up a privacy policy and we're good. That's really like a Band-Aid to a significant wound that is not going to go away. And it will peel off and that wound will be exposed. And so do that operation, right? Like get to the meat of what your vulnerabilities, weaknesses, and gaps are. Identify it, and then you'll start to recognize what your privacy obligations really are. And then once you're able to identify that, you can start to sew it all up, right?
Yeah.
And once you do identify what those risks are, I know this is probably number 2. I know you asked for one.
No, carry on. I won't tell anyone.
Okay, thanks. You need to make someone accountable. Like there's so many companies that will do this risk assessment. Oh, thank you. Like, you know, you've identified all these risks, but then it's just like a report that's sitting on their desk without doing anything about it. Who is going to be accountable? Who is going to recognize the privacy risks? And if it's going to be someone within your organization already, then make sure that they are qualified to do it. Because if you just pick someone out of a hat and say, okay, you're responsible for privacy, who's to say they're actually going to be able to recognize privacy risks? So enable that person, send them for courses, send them to seminars, conferences, get them the proper resources, or get a privacy expert to train them, like a train the trainer model, which I often do with organizations that decide, we want someone within our organization to take over that role, but they need a lift. They need someone to show them the ropes. And so once someone is accountable, they can enable the entire organization and create a privacy culture. Everyone needs to think of privacy. Privacy is in every little crevice of your business, and everyone needs to open their eyes and ears to privacy. That one privacy lead or privacy officer cannot be at all places at all times.
Yeah.
So their job is to create that culture so everyone is thinking about it and brings up any risks to that accountable person. I hope that answered your question.
Yes, that does.
It's just the foundation of, privacy, really.
Yeah, no, I love that answer. And I see it so many times, and I can absolutely attest to that. Sharon, we're coming to wrap up. If someone wants to get hold of you to find out a little bit more or discuss this further or discuss your services, where do they go about doing that?
Sure, they can go on my website, www.bamboodataconsulting.com. They're free to email me at sharon@bamboodc.com. And I'm on LinkedIn, so reach out. Happy to communicate with you. And by the way, hold on, I have to say something. I don't know if I ever told you. My husband is South African. Did I ever tell you that?
I think you mentioned it right when we first met.
Sorry?
I think you mentioned that when we first met.
Probably. Anyways, I feel the connection. I love your accent. Thank you so much for having me. And I hope you and your viewers found this informative.
Oh, absolutely. I'm sure everyone will. That was fantastic. Sharon, thank you so much for being here. Folks, thanks for listening, and we will catch you on the next episode. Thanks very much. Have a good time.